arguments and the underlying facts. So I would encourage you both to jump right in. We do not anticipate any problems with the technology, but if we do, we will be patient with you, and we hope you are patient with us as well. So with that, I will turn it over to Mr. O'Leary from the Commonwealth.
Thank you, Justices. Kevin O'Leary on behalf of the Commonwealth. It is the Commonwealth's position that the trial court abused its discretion in dismissing a legally adequate complaint and did so by taking evidence without the Commonwealth's consent, pursuant to Commonwealth versus Bell, which I know is cited in both mine and the appellee's brief. It's my position that in Commonwealth's Appendix 6, which contains the application for complaint, that was legally adequate for probable cause to arrest, showing that an abuse prevention order was issued, was in effect, that the defendant violated it by sending a Facebook message, and that the defendant at the time knew about the terms of the order because he had been served by a Wareham District Court officer.
So the defendant comes forward and says, hey, I sent this at 11:19 a.m., about an hour and a half before the abuse prevention order entered. If he's right, there's no case, right?
If he is right, there is no case. That's correct, Your Honor. However, taking into account that evidence, I would suggest the record clearly shows that even by trial court defense counsel's own admission, that wasn't turned over to the Commonwealth. I know in the appellee's brief, there is the additional transcript from arraignment. And within the argument from the appellee, it's that the Commonwealth, the exact words were, had been alerted to the evidence. But what it doesn't say, which is cleared from the record, is that evidence was in the defendant's control and then not turned over to the Commonwealth. Did the Commonwealth ever ask? I believe it's not clear that the Commonwealth ever asked, no. But so
why, when the Commonwealth's at arraignment and they say to the judge, boy, this is an interesting issue, quote unquote, did they not ask to see the phone?
It's not in the transcript, so I can't say the Commonwealth did, Your Honor, no. From reading the transcript, it appears that—
Doesn't the Commonwealth at least have an ethical obligation to determine that it has probable cause to continue forward with its prosecution at all times during a prosecution?
Yes, Your Honor, but with the evidence being in the defendant's control and then the defendant saying, I have this potentially exculpatory evidence, part of my confusion is why that wasn't turned over. That even though during the bail argument, the Commonwealth did take defense counsel at their word, that's in the transcript. At that point, going forward the next probable cause date, defense counsel states on the record that I haven't been able to get anybody's attention. And I don't see how that's how discovery works. If defense counsel has it and wants to give it to the Commonwealth, they say within the transcript, I have these screenshots. They could have easily been turned over to the Commonwealth. When in the brief, the appellee states the Commonwealth did not make an attempt to get third-party records. Here, it's clear that it's already in the defendant's control.
But counsel, can you agree with the proposition, the abstract proposition, that if it becomes readily apparent to everyone that the Commonwealth cannot make out its case, shouldn't the judge have the authority to dismiss the case?
I think on that point, it's on the Commonwealth to dismiss the case, Your Honor. And one of my concerns in writing this brief was how the discovery apparently was still never turned over, that they're in a pretrial hearing, the court asks to see the phone, it's presented to the judge. At that point, the judge indicates in the transcript, it's Commonwealth's Appendix 11, to prompt that if the defendant were to move to dismiss, I would. At that point, the case is dismissed, and it's not clear that the Commonwealth ever got to see the evidence. It was cut out of the entire determination.
Well, there is nothing in that record that suggests to me that the Commonwealth didn't see the phone. He never says, I didn't see the phone. He never objects to the judge looking at the phone. What he objects to is, quote unquote, I haven't had the opportunity to determine whether it's been tampered with.
Well, I would say it's defense counsel's own statement. I haven't been able to get anybody's attention that they have the evidence and that they haven't been able to turn it over. And I would note the Commonwealth's not objecting.
Who has the response? Help me with this. From the Commonwealth's perspective, who has the responsibility at that point? Defense counsel raises that I have evidence which I believe means that there is no probable cause, there is no case. He brings it to court. The court looks at it. My reading of the record is that your guy never says, I haven't seen what he's showing you. In other words, the Commonwealth never says that. Where does the burden lie at that point under our law? You seem to be suggesting the defendant had an obligation to affirmatively provide the evidence to the Commonwealth. And I understand that point, but I'm stuck on you guys are responsible for determining at all points in your prosecution that you have probable cause. Am I wrong about that?
No, I agree, Your Honor.
Okay, so if you're responsible for that and someone says, I have literally the silver bullet, shouldn't you take the steps to determine whether it is in fact the silver bullet?
Yes, Your Honor, but to that point, I believe it's the first pretrial hearing and it's in defense counsel's hand. It's with the defendant in the courtroom. I'm not sure how at that point the Commonwealth is supposed to have that evidence.
Well, no, come on. We've all been in court a gazillion times. When you hand something to the judge, opposing counsel gets to see it. And there's nothing in this record that suggests to me that opposing counsel didn't see it. I would be stunned if that's what happened. The judge looked at it and the Commonwealth never said, could I see that, Your Honor?
My review of the record, Your Honor, is the court saying, I would like to see the defendant's phone and the phone being handed up to the bench.
I haven't had the opportunity to determine whether it's been tampered with, is all I read. Have I missed something?
No, Your Honor, that's what I read in the transcript.
But isn't that different?
It is, Your Honor. It's different in the transcript, but from my reading, it sounds like defense counsel says, I haven't been able to get anyone's attention. The court saying, I would like to see the phone, and then the phone being passed up.
Now, counsel, put yourself into the perspective of a defendant in this situation where he feels he has conclusive evidence that completely wipes out the Commonwealth's case. What were his options at that point for getting rid of the case?
As I suggested before, I believe the evidence should have been turned over to the Commonwealth. I understand it's, in their view, potentially exculpatory.
No, it's not potentially exculpatory. It wipes out the Commonwealth's case unless the suggestion that it actually has been tampered with is proven.
I believe it should have been provided to the Commonwealth. The concern is, in my view, the Commonwealth was cut out of this determination.
You weren't the counsel in the courtroom, right?
Correct, Your Honor.
Have you communicated with the counsel who was in the courtroom?
Yes, Your Honor.
Can we go back to Judge Milkey's question, which I think is sort of the nub of a problem that I've been musing on since I saw this. What role do the courts have when presented with a motion to dismiss in the context of a case where it suggests to them that they've seen no evidence that there is in fact a basis for the Commonwealth to go forward? Are they to put blinders on?
No, Your Honor. I know I keep going around in a circle with this, but my concern with this has been the Commonwealth being, from my reading, just removed from the decision, where the court asked to see the phone, and from the judge's statements within the transcript, well, I know I should stay in my lane. I know, what do you want me to do? What do you want me to do? And eventually the court saying themselves, if you raise the probable cause, and the Commonwealth there on the side, unaware, I would suggest to this point, that this is going to be a motion to dismiss after the court has reviewed evidence, and at that point prompting a motion to dismiss. So my concern has been the Commonwealth has been removed from this. I don't see evidence from the transcript that the Commonwealth had seen the defendant's phone itself, and that's being taken from defense counsel's statements and the actions leading up to the motions to dismiss, Your Honor.
Well, he says, I haven't had a chance to inspect this defendant's phone. I don't know if it has been tampered with in any way.
What are the chances in a case like this, which let's just say is very far from a murder case, the Commonwealth is going to hire an expert to do a forensic search of the phone to try to determine if it's been tampered with?
It's highly unlikely, Your Honor.
So then why are we here?
I think it goes back to the point, Your Honor, the Commonwealth never had the opportunity to review evidence that was presented at a hearing that the Commonwealth appeared to not be aware it was a part of, because it was only at the end of the judge reviewing the evidence, reviewing the phone, prompting the, if you moved for a motion to dismiss, defense counsel saying yes, and then the judge dismissing it right at that point, with the Commonwealth having
Right, he dismisses it without prejudice. Do you agree with that?
Yes, Your Honor.
So the Commonwealth doesn't ask to see the phone at arraignment. It doesn't, at least according to you, it doesn't ask to see the phone when the phone is used as the basis for dismissal. And then there's no record that it asked to see the phone after dismissal, after the judge says, you have some more investigation to do here. Do I have the record right on that?
That sounds correct. Yes, Your Honor.
Okay.
Is it going back to Judge Englander's question about why are we here? Is it fair to say we're here on the principle of the thing, that the judge did something that the Commonwealth thinks is inappropriate, namely looked at evidence on a motion to dismiss when Bell says you can't do that?
I would agree that's part of the reason, Your Honor. And I've repeated it, so I don't want to keep repeating myself. I know Your Honors have listened, but it's how the Commonwealth was cut out, how this was a conversation.
But that sounds like principle as opposed to substance to me.
The case was dismissed, Your Honor, so there was substance there. I understand it was without prejudice, as Justice Englander pointed out. I agree with that.
But you've said that it's highly unlikely the Commonwealth is going to pursue an expert to try to prove that this was tampered with. That being the case, there's zero chance of the Commonwealth proving this case, it would appear, in which case, why are we here? And I understand the principle of it, but I just want to note that sometimes cases brought on principle can backfire. Two members of this panel were on Commonwealth v. Tejeda, which was a broadly analogous case in the sense that the judge did something that on its face looked inherently reasonable, but it ran up against a long line of cases that said she couldn't do that. Our panel reluctantly reversed what the judge did based on that case law. The SJC took the case and flipped it. Another example of hard cases changing the law.
And the lesson that one might have taken from Tejeda is you have to look really hard when you're applying a rule in a situation where it doesn't seem to make the best sense for the process as a whole.
I would put it more bluntly, it is arguably inconsistent with the idea of doing justice.
And if I may add one point, Your Honor, the Commonwealth would still have the evidence that it has in the application for complaint, the message that the victim received after the order went into effect. So I understand the defendant is saying here, I have something, but without that being provided, it wasn't able to be weighed against the Commonwealth's evidence.
No, I think we understand your legal points. It's the bigger picture I think we're questioning in terms of why are we here, and is this the case the Commonwealth really wants to bring to have this proposition tested?
The difficulty I have, counsel, you've done the best job you can do with the record that you have. The difficulty I have is that the record is devoid of the Commonwealth doing what one would hope the Commonwealth would do: ask to see the phone. They had 3 separate opportunities to do that. Unless I'm missing something, I mean, help me, am I right that that's the record?
That appears correct, Your Honor. I know I keep pushing back with it. It's in the defendant's custody.
But they can ask.
Yes.
Then the defendant is, it seems to me, then the defendant's in an awfully difficult position. The defendant says, no, let me tell you, this is what the phone says, but you can't see it. Well, then, all the equity's just shifted to the prosecution.
All right. Thank you, Justices.
Do either of my colleagues have any additional questions? Hearing none, thank you very much. We'll hear from Ms. Oresti.
Thank you. May it please the court, Megan Oresti for David Murphy. Our argument really is that this was a proper dismissal. It was, the judge properly evaluated the probable cause for complaint, and it really was within the 4 corners. The sending of the message is the violation. So the basis of the complaint is this message. The evidence the judge is evaluating is related to the message. This isn't some other message. This isn't some other evidence that was brought in. He properly evaluated what the basis of the complaint was. The sender, it gets a little bit into technology, but the sender of a message doesn't control when it's received. And because this message that the complaint is based on is a message.
So I think I understand this argument. I recall the argument from your brief very well. Let me ask you this question. Do you say, I take it your argument is, probable cause is lacking based solely on the receipt after the time that the order entered?
Yes, that's one of our
That's
arguments.
a pretty tough argument, isn't it? Because everybody texts all the time, and we all operate on the assumption that we've received that text within a fairly reasonable approximate time to the time it was sent. The reason we assume that is because it's proven to be true time and time again.
Yes, it's true. And the majority of messages are received within minutes. But I will point out this particular message was received in minutes. We're not talking hours and days. And the police knew that she had been in court and in a police station where cell phones are required to be turned off or put in airplane mode, which would delay the delivery of messages, as commonly anybody who's been on an airplane knows. When they land, they get all their messages load up. So I do think that the judge properly evaluated.
There was no evidence that she'd been in court between 12:40 and 1:39. She'd been in a police station. We don't know what the situation is in a police station in whatever, was it Wareham?
Yes. Yeah. So again,
there's no mention of that in the record.
No, there is mention of her being at the police station to drop off a copy of the report, so that she went from the court where the restraining order was issued.
Right, but there's nothing in the record that tells us the ability to receive a text in the Wareham police station.
I don't believe so, no. There's general information on, things that can delay text, including having phones be turned off and so forth. And I think given that we're talking about a very short time frame, and the fact that the police were, the prosecution was made aware that the text message was sent earlier. My brother pointed out that the cell phone was in, David Murphy's cell phone was in his custody, so they couldn't view it. But if you look at the arraignment transcript, the cell phone was in lockup. He was incarcerated at that time. He was being held. And so the phone probably could have been accessed by them at that time. They were aware of the discrepancy, and they actually, in the arraignment transcript, they say, the Commonwealth says, we're considering that and not asking for bail. So they were well aware this isn't new evidence that was sprung on them at the hearing. This was something they were absolutely aware of. And again, in terms of the judge's evaluation, he's evaluating the evidence that's the basis of the complaint. He's not looking at some new evidence that came out of nowhere. This is
But I'm having a hard time seeing how that makes this a four corners case. In the sense, I mean, the phone is still evidence of the allegations in the complaint, but the phone itself isn't within the four corners of the complaint.
No, but when the message was sent is the violation. So contact is the basis of the violation. It's not the sending of the message is how he violated is the basis of the charge. It's not when she received.
Right, understood, but the evidence that's in the probable cause determination is her receipt. And unless you can convince us that the receipt is not probable cause of when it was sent, then you've got a pretty tough road on a probable cause standard, right?
I think it's challenging, but I think if you're looking at the judge at the hearing evaluating this case, he's considering evidence that relates directly to the message that's the basis. He's not he's doing it because defendant brought it to his attention through the proper motion for dismissal. This wasn't a sua sponte judge saying, hey, I disagree with this complaint, I'm dismissing it. This was, the proper channels were followed.
Well, ordinarily the rules say that you have to put a motion to dismiss in writing, but nobody raised that. And I understand the case law is that if it's not raised, it can be done orally. But why didn't the defendants offer the phone to the Commonwealth?
I don't think the defendant had any objection to anybody in the room looking at the printouts that they brought. I believe copies were brought for the Commonwealth and for the court to look at. I think the judge felt he was doing due diligence by taking it a step further and looking at the actual phone because maybe the printouts were maybe tampered with, and that was in his mind. I think double checking what the defendant was bringing forward. Again, the Commonwealth did not ask specifically to be handed the phone. They didn't even object to the evidence being shown. The only objection was to the dismissal. So there is case law that says that additional evidence, if that's what we're calling this, can be considered with consent of the parties. And I would say here, the Commonwealth's lack of objection to the evidence being presented was consent, and that's the judge properly considered.
Well, but that's a tough argument, isn't it? Because he says, I would object. The reason being is I haven't had a chance to inspect this defendant's phone.
That's after dismissal, but when at the arraignment.
Well, that's the first opportunity he has to say anything.
Well, at the arraignment, they're made aware of this, though. This isn't something that was sprung on them. They had ample opportunity to request this evidence, to do their own due diligence. It comes in at hearing. The court and the defense counsel go back and forth on it before he dismisses it. The judge actually asked the prosecutor, is there any other evidence? Is there anything else here? And the answer is, I believe he said, no, there's no other messages. So, I feel that the judge did engage the prosecution in the conversation as he was analyzing this evidence, and they did not object until after the dismissal. So I would say, in a way, they consented, and they knew about.
You weren't present, right?
I was not, no.
Okay, so what if instead of dismissing the case, the judge had said, Commonwealth, it looks like you don't have a case, but I can't dismiss it today, except based on the four corners of the complaint, and therefore I'm not going to do that. Other than taking up Mr. O'Leary on his option of trying to convince the Commonwealth to drop the case, what were your options? What would your options have been at that point in a district court proceeding such as this?
Well, I think if the motion to dismiss was denied, I think you would bring it, you'd put in a written motion and request another hearing.
But based on what? I mean, again, in the informal district court practice, what pretrial opportunities do you have for the judge to look at actual evidence in order to determine that there is no probable cause, much less proof beyond a reasonable doubt?
Well, I think if you look at some of the case law that I found, including the Everett case from 2015, this court says that a complaint may be found invalid for a variety of reasons, including issued without probable cause, in violation of double jeopardy, or where evidence to be presented at trial is insufficient to support a conviction. So I think under that case law, the district court could have on a written motion to dismiss.
Not the way I read the cases. I did an awful lot of reading of cases, and probable cause without the consent of the Commonwealth is not something where you take evidence, at least the way I read them. It goes back many, many years.
Well, no, I was saying if this particular circumstance had not ended with a dismissal, the next option would be to do a motion to dismiss and have a hearing.
Right. What I'm saying is the judge, as I read the cases, and you can disabuse me of this, but you should do it now. As I read the cases, the judge does not have the option to have an evidentiary hearing on probable cause without the consent of the Commonwealth. The cases say that is reserved for trial unless the Commonwealth is willing to do it at the probable cause hearing. Am I wrong?
No, I did find the Everett case that pointed to the evidence presented at trial will be insufficient. So I think there's some argument there, but I do agree the majority of cases say that it's, a judge is not allowed to just dismiss after reviewing additional evidence on probable cause and complaint. I would agree with you there. But again, I would say that that's what he was doing here. And I would also say that if this evidence is being looked at as separate, independent evidence, even though it relates to the text message that was the underlying basis for this complaint, I would say that the Commonwealth consented. They knew about the evidence. The evidence was not sprung on them, and they were part of the discussion at the hearing, and they didn't object until the.
And the reason for the consent is because when the judge asked to see the phone, or when defense counsel first offered the screenshots, the Commonwealth never said, I object to you taking any evidence. Is that the argument?
Yes. And I also think that, the fact that you can't ignore the fact that this wasn't new evidence for them. They were aware, this was brought to their attention multiple times before this hearing, including at the arraignment when the phone was in their possession in a locker because he was being held. So I would say that, yes, their opportunity and their awareness, their opportunity to object at the hearing.
If the Commonwealth gets off the phone and says, I'd like to see the phone, can you deliver the phone at this point? Would you deliver the phone at this point?
I think that the defense would have provided the phone had
No, I'm asking about right now. You see, there's another issue that's overlaying all this, which is the Commonwealth's obligation to determine that it has probable cause at all instances during its prosecution. If the Commonwealth asked, I'd like to see the phone, would you be able to do that? You can just answer it yes or no. Or I can't answer.
I believe yes. I believe the messages have been saved. I do agree that I think there was a complaint issued, and multiple times during the prosecution leading up to this hearing, there was, a lack on the prosecution's part of investigating, requesting, or doing anything on their part to look at this evidence, which was critical to this message. And again, I think it's not outside of the basis of the complaint. The sending of the message is the violation. That's the point of contact. And even though it isn't the regular way messages are received, there is the delay, and the delay was brought to their attention.
Can I just clarify one point? When you say the Commonwealth had possession of the phone and lockup, it couldn't look inside the phone without a warrant, putting aside password issues. Correct?
But it could have gotten the defendant's permission to look at the phone. I mean, the defense counsel says the cell phone's downstairs in lockup, and he informed me that he sent the messages at 11:19. It wasn't received by the complainant until the time listed in the report. So I think there's a defense, and I asked the court officers to at some point take steps to recover the information from the cell phone and lockup. That's read straight from the arraignment hearing transcript. And I would also just end with, the dismissal. The defendant argues adamantly that the dismissal was proper, that it was done via the proper vehicle, and also that it was done without prejudice. That the judge in this case asked the prosecution, "Is there other evidence? If you get other evidence, you're more than welcome to bring this back." So the prejudicial effect was slight.
Slight or any?
I said slight.
No, I understand.
So if that's all, I will rest on my brief.
Well, it's certainly prejudicial to a defendant. And one would hope that the Commonwealth would have probable cause before they pursued that. Thank you. I don't have any further questions.
Hearing no further questions, that concludes our session. I do want to add that we will do our job in resolving this appeal, however we come out. In the interim, should either party wish to communicate with the other about trying to resolve this, short of our doing so, we're not going to stand in your way. As I said before, this may or may not be the case the Commonwealth wants to choose to try to prove a point. With that, we are going to conclude. We thank you both for participating by Zoom. We thank the clerk's office and our IT folks for setting